Welcome to the video. First, we will introduce the central myth that active duty status by itself automatically speeds up a spouse's green card process. Then, we'll preview what truly matters for an expedite under USCIS policy. We will use clear frameworks and diagrams to guide you. By the end, you will understand the difference between hardship and status, how to request an expedite correctly, and how to avoid common pitfalls. Here is our roadmap. First, we separate myth from reality. Next, we explain I-130 basics. Then, we clarify hardship versus status. After that, we show how expedites work and what documentation to prepare. We will also cover pitfalls and pro tips. Finally, we will test your understanding with a quick quiz and summarize key takeaways. Before we dive in, here is an important disclaimer. This video provides general educational information and is not legal advice. Immigration policies and timelines can change, and individual facts matter. For personalized guidance, consult a qualified immigration attorney or accredited representative. Now, transitioning to the basics. The I-130 is the petition for alien relative, the foundational form for a spouse's green card process. It establishes a bona fide qualifying relationship, but does not, by itself, grant permanent residency. It is the first brick in the larger immigration path that includes either consular processing or adjustment of status, depending on the case. Next, let's clarify misconceptions. The myth is that active duty service automatically speeds up I-130 processing. In reality, USCIS does not generally expedite based solely on service status. Expedites require a formal request paired with strong evidence of urgent hardship. Additionally, there is no premium processing service for I-130, unlike some employment-based forms. Moving on, here is the crucial difference. Hardship versus status. The most persuasive basis for an expedite in military spouse cases is official permanent change of station orders to an overseas location, which can create imminent and involuntary separation. This is the type of urgent, verifiable need USCIS may recognize for expedited treatment. Without such circumstances, your case generally remains in the standard processing line. Now let's visualize the path using a sequence diagram. First, the applicant files the I-130. Then, USCIS issues the receipt notice, known as NOA1. If there is a qualifying hardship such as PCS orders, the applicant submits an expedite request with evidence. USCIS reviews the request and may ask for more evidence. Finally, USCIS either approves the expedite, which accelerates adjudication, or denies it, in which case the case returns to the standard queue. Next, here is a step-by-step guide to requesting an expedite. First, verify that an expedite basis applies, such as PCS orders or another urgent humanitarian hardship. Second, collect evidence including official orders, deployment dates, command support letters, proof of the marital relationship, and any humanitarian records. Third, submit the request through your USCIS online account if available, or contact the USCIS Contact Center, or use the EMA chat system as directed by current USCIS procedures. In the request, clearly explain the emergency with specific dates and locations. Attach readable, well-labeled PDFs. Then, track your request and respond promptly if USCIS asks for more information. If the expedite is denied, continue with the normal process and keep your documentation current. Here is a practical checklist. Include official PCS orders or deployment notices with dates and destinations. Add a command letter explaining the operational need and probable separation impact. Provide evidence of a bona fide marriage, such as marriage certificates, joint leases, joint finances, and appropriate photos. If humanitarian issues are relevant, include medical records or caregiver statements. Use a concise cover letter that summarizes the hardship and lists exhibits. Finally, ensure the I-130 receipt number and applicant identifiers are clear on your cover materials. To make this actionable, here is a simple, adaptable template for your expedite request. Include the I-130 receipt number, your PCS destination and report date, beneficiary details, and a concise list of attached evidence. Keep the narrative short, factual, and focused on the imminent separation and official orders. Insert your specifics where indicated and ensure all attachments are properly labeled. Let's compare common scenarios. PCS orders to an overseas assignment with a near report date are strong for Expedite because they create imminent, government-directed separation. Impending deployment may also justify an Expedite, depending on timing and impact. Being stationed in the United States without overseas orders typically does not justify expedited treatment. Serious medical hardships are considered case by case. Pure financial inconvenience, without more, is generally insufficient under USCIS standards. Here is a mind map that organizes recognized expedite grounds in a military context. The central node branches to PCS to overseas, impending deployment, urgent humanitarian reasons, severe financial loss, clear USCIS error, and compelling U.S. government interest. Under PCS, note the imminent report date, separation risk, and command letters. Under urgent humanitarian reasons, note medical treatment needs, caregiver responsibilities, and safety concerns. Severe financial loss is included, but requires proof that the loss exceeds ordinary inconvenience. Quiz time. Question: which situation most strongly supports an expedite for a military spouse's I-130? Options are: active duty status alone, PCS orders requiring overseas relocation soon, sending USCIS a social media message, or paying for premium processing of I-130. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is PCS orders requiring overseas relocation soon. Such orders create a documented, imminent separation that USCIS may view as an urgent hardship. There is no premium processing for I-130, and status alone does not qualify. Messages on social media are not a recognized expedite channel. Now for best practices. First, submit a complete and clean I-130 to avoid delays from requests for evidence. Second, if hardship applies, submit the expedite request promptly instead of waiting for USCIS to recognize your status. Third, label and index your evidence clearly to facilitate officer review. Fourth, set expectations. Without urgent verifiable hardship, anticipate standard processing times. Fifth, do not confuse parole in place with an expedite. They are separate programs with different purposes. Finally, consider professional legal guidance, particularly when facing tight timelines tied to orders. Next, common pitfalls. Do not assume that military status automatically accelerates processing. Avoid submitting vague expedite requests without concrete evidence. Do not send illegible or incomplete documentation. Clarity, organization, and specificity are essential to success. Second quiz. Question: which of the following will not, by itself, speed up an I-130 for a military spouse? The options are: active duty status alone, PCS orders with a near report date, a documented medical emergency, or an explicit expedite request supported by evidence. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is active duty status alone. USCIS focuses on documented, urgent hardship. PCS orders, a documented medical emergency, and a properly supported expedite request can justify faster processing, but status without hardship will not. Here are the key takeaways. First, active duty status does not automatically lead to expedited I-130 processings. Second, the strongest expedite ground is imminent overseas PCS orders creating separation. Third, you must proactively request an expedite and document the hardship. Fourth, without hardship, plan for standard timelines and focus on submitting an error-free petition. Finally, clear evidence and concise explanations increase your odds of success. To wrap up, we debunked the myth that active duty status alone speeds up the I-130. We clarified the hardship versus status distinction and highlighted why PCS orders are typically the strongest expedite basis. We covered how to request an expedite, what evidence to include, common pitfalls, and practical tips. This provides a clear framework to approach your case strategically. Thank you for watching. If this video was helpful, please like, share, and subscribe. In the comments, tell us your questions or experiences so others can learn from them. Your engagement helps the community and supports future content.